contractual asset protection is about sharing the load and sharing responsibility so that the people who are best placed to take that responsibility have that. And the reason contractual asset protection is needed is because operational excellence usually isn't enough. I had an instance of a client who is in the wholesale wine business who does everything by a handshake, runs a fantastic business, he's been very successful, and he put some wine in a container and was sending it over to England, and it fell off the ship. And it had nothing to do with, it wasn't his fault, the wine was fine, the container was fine, when it left his place it was fine, and it was one of his major customers. And I said to him, so what were the terms of supply? Was it free on board, or when did risk pass? Well, don't have terms of trade. Okay. What's your insurance position? Oh, I don't know. Who's your insurance broker? He thought that just being a fantastic bulk wine procurement and processor was enough, and it was enough for many years, and he built up a considerable amount of wealth. Next thing, he has a couple of $100,000 worth of wine fall off the side of a ship somewhere between here and the UK. And he could have so easily managed that risk with some contractual asset protection. So, terms of trade. The first thing I say to a business owner when I meet them is that the wonderful thing about Western society is that you get to choose, pretty much, subject to some sensible legislation I think, you get to choose the terms on which you do business. But almost every business person I meet doesn't exercise that choice, in the sense of having terms of trade in place with every one of their customers and reviewing them and using the terms of trade as an opportunity to set expectations rather than just sort of pushing it across the table, or not pushing it across the table at all because I don't want to offend anybody. So make that choice. And things that you want to see in those terms of trade is obviously compliance with the Competition and Consumer Act, which is some basic things. But you can limit your liabilities, you can limit your warranties, and then you can pass title and risk in relation to the assets that you're supplying. And there's some new issues there with the PPSA, which is about basically retention of title and the things that you need to do to actually make those clauses work. That's when you supply something and you can take it back if you don't get paid for it. And guarantees. If you're dealing with the $2 company, make sure that you can shoot that home to somebody. The next thing is employment contracts. So once again, share the load with your employees. See it as an opportunity to have a discussion about the responsibilities you're going to be expecting of them in order to be able to keep them employed. And obviously protect your customers' IP and things like phone numbers with a reasonable restraint with every one of your employees. And use job descriptions. Once again, too many words on a slide, but general insurance is a form of contractual asset protection. That's what an insurance contract is. You're borrowing the balance sheet of the insurance company to protect your business assets. And really, I see an insurance contract as a cash flow device. Because if you don't insure, you don't pay anything, bang, massive output, don't pay anything, bang, something goes wrong. Whereas if you pay insurance, you just pay a little bit along the way. So see it as a form of cash flow funding, if you like. And then external threats, you would apply contractual asset protection by having constitutions and shareholder agreements in place to deal with your business partners and to deal with your shareholders and to regulate the things that you are expecting of the directors in the business. Buy, sell and exit agreements so that you don't destroy the business wealth at the end of, on the exit, or when something happens which is not a planned exit, like someone's death or disability or that sort of thing. Have joint venture terms with other businesses. There's a lot of informal joint ventures and a lot of informal business activity occurs, and they are a great source of litigation and dispute and ultimately destruction of business value. So take the time up front to talk about what those terms are and document them. And in relation to things like the external threat of a spouse, and not just your spouse, your business partner's spouse, there are things, and they're sometimes a little bit difficult to put in place, but things like a binding financial agreement, even if it just relates to the business interest, can save a lot of issues down the track. So practical steps: agree the terms with all customers, agree terms with all suppliers, have a written agreement with all employees, agree terms with all business partners. So you can see there's a lot of legal work there, which is obviously why I'm up here nabbering on about it. Maintain a contract register, maintain an insurance register, and maintain a guarantee register. So really, so far in relation to operational asset protection and contractual asset protection, I'm talking about putting common sense things in place and common sense systems to monitor those defences, those asset protection elements. So we move to structural asset protection. And really the guts of structural asset protection is keeping things separate, separating risk and separating harm, separating assets, wealth. So risk and harm and wealth. So it's about creating genuine boundaries that are going to withstand an attack when those risks hit. And we're seeking to manage it by quarantining those risks and keeping wealth out of harm's way. And as I said at the outset, this is really the Armageddon defence. This is not something that you start with. We're talking about your business is blown up or something's blown up outside your business and you're relying on your legal structure to leave you with something. That in my view is really, that's why I've sort of labelled it the other two elements of asset protection, because in practical terms, they're going to have the most impact on your business. Key thing about structural asset protection is you've got to get it right at the outset. It's very hard to restructure. I'm going to talk about some restructures, but it is hard to do something down the track, because there are a number of impediments. There's a tax cost associated with restructures, and sometimes those tax costs are actually that it won't be effective for tax, or it'll be ineffective, or there'll be a cost. And as far as the actual asset protection element of a restructure, there's the bankruptcy and insolvency laws that seek to claw back the assets that you've moved out of harm's way. And the other thing about structural asset protection is that the benefits are in the details. So if you log on and you pump out a trust deed and you throw it at a client, or that's thrown at you if you're in business, chances are it's next to useless from an asset protection perspective. So really it's a business entity for tax purposes and just general administration, because it won't be set up right. And that really is a truth. That's what we see all the time. And your motivation in the context of structural asset protection is very important, because any structure or strategy that has asset protection as one of its main purposes won't be effective for asset protection purposes. That's the way the bankruptcy laws and the insolvency laws are drafted. They actually say if your main purpose is asset protection, it will not work, and we can go back up to 5 years and claim it all back. So if the main purpose, if you turn around to the trustee bankruptcy, well, the main purpose was tax efficiency or tax effectiveness, then chances are it won't be tax effective, because the anti-avoidance provisions of the Tax Act say that if the main purpose is tax effective, then it's not effective. So given that the tax office is usually the number one creditor in an asset protection type scenario, you're really left with a catch-22 there. And so in my view, you need to identify a legitimate motivation, and the only legitimate motivation is real change. For example, refinancing. If you're refinancing, you get to choose where that finance comes in. Now, if you can cover some business wealth with security, which we'll talk about later, that's a way of getting some asset protection, then that's the main purpose there was refinancing. And if a bank prefers to lend to someone who's got assets, I don't think that's a big problem either from a tax perspective or an asset protection perspective. The other ones are if somebody new comes into your business. That person, as they're coming in new, really gets a choice as to how they want to engage with you. And you might be setting the business up to pass it down the track, or you might be entering into a joint venture agreement or a joint venture arrangement with somebody. So what I'm saying is that in the absence of a real change in your circumstances, I think you're going to very much struggle to put in place effective asset protection and have it work, or at least be efficient from a tax perspective, let alone get any tax benefits. So I guess that comes back to the sort of snake oil proposition at the outset, is that if you're almost insolvent, or you're just feeling uncomfortable for some reason and you want to make a change, and what you want, it's really driven by an asset protection concern, I would be very interested to hear how it turns out, because if you look at the recent line of cases, They've just torn through a lot of that structural asset protection right up to the High Court, which once again we're going to touch on. So as far as putting your structures together, it's really there's you, there's other people, there's companies and trusts, and there's a combination of both. And fundamentally, I think it comes down to you, a company, or a trust, and a combination of those. That's really it as far as your building blocks. And the first bit of advice is pretty obvious, but avoid trading in your own name because it brings with it personal responsibility for everything. And people then say to me, oh, look, I'm just setting it up, that doesn't matter. I don't own any assets, I'm a man of straw. One thing I say to people is, first of all, if you're setting up a business and you can't afford $900 for a company, then your business idea sucks. You've got the wrong idea, right? And you've got the wrong mentality to be in business. Second thing I say is, man of straw strategy is a really bad strategy because going bankrupt has massively long-lasting consequences. Not inability to be a director, inability to hold professional qualifications, inability to be a builder, losing trade type qualifications. And it lasts for a long time and it's a stigma that goes with you forever. Whereas being a director of an insolvent company still has stigma attached to it, but nowhere near the consequences. And your ability to negotiate out of a corporate insolvency through some sort of an arrangement is a lot higher than if you're personally on the hook because people take it personally. I can bankrupt you, and I'm going to bankrupt you because I can. Whereas in a corporate insolvency, I'm going to put your company in insolvency, blah, blah, yeah, whatever. So it's a different level of personalness. So I think that the man of straw idea is something that's overrated. But if you get in the habit of being involved with a lot of companies that go broke, then there will be personal stigma and there'll also be a lot more consequences for you. Avoid partnerships. Basically, your partners have the authority to go out there and get you in trouble. And you don't necessarily know what you're going to be liable for until it's too late. And avoid informal partnerships. If you agree to share profit with somebody, you've just created a partnership. And if they do something in the context of that activity, you're liable for it. So I guess there is the importance of documenting your joint venture arrangements and documenting authority. So we've really wiped out yourself and partnerships, so we come to companies. And they are an effective business vehicle. This has been designed, set up to limit how much assets you're putting on the table and putting at risk. So you've got separate legal identity, limited liability, separation of ownership and management, structured management principles and accountabilities. You get the Corporations Act for free. You don't have to pay for a partnership agreement. It just all gets imported. And it provides a sort of a structured relationship between co-owners and it lasts forever. So well, certainly until someone decides to shut it down. So a company will quarantine the risks within your business from you as a shareholder to some extent to you but at a lesser extent to you as a director, but it won't quarantine the risks within the business, so within the company itself. So those core operational risks that we're talking about, or the internal risks. But it's still a form of, the $900 is very, very cheap insurance and it lasts every year that company's in existence. But it won't protect you from personal attack. So, a lot of this is sort of 101 stuff, but I think to some degree it's worth a refresher on a morning. So if there's a business liability and it travels down, it will not go as far as the owners, and as I say, it generally won't go to the directors unless there's some sort of level of culpability in there. So it can still, the risks within the business can still wipe out those business assets. But if there's a personal liability, so you're attacked personally, then your value as represented by your investment in that company is at risk. So it's a one-way, I call it one-way asset protection coming down. And then you need to think about things like who's going to be the shareholder and how much they're going to agree, how much they're deciding to put on the table. And we're seeing in the context of building companies and those sort of things where you have to have a certain amount of capital, but a lot of them don't pay it up. They do partly paid shares, paid to 1 cent, but they agree to put $1 per share. And then something goes wrong, the first thing a liquidator or an administrator does is calls up the uncalled capital. And a lot of people don't understand that consequence. They are personally liable for everything they agree to subscribe, even if it hasn't been paid up. And then the shares, as I said, the shares themselves are going to represent an investment, an asset. So they should be held by somebody who's not going to be subject to attack. And the persons who hold those shares can be either the individuals or a trust. Then we need to think about who's going to be a director. And the obvious thing to do is to limit the number of people who are directors and choose with care. because although the shareholders get statutory protection, the directors are still on the hook for those 700 issues that we talked about before. A lot of them, you wouldn't even know until they happened. And things like the responsibility for employees and people who come on your premises are so onerous that you really need to think carefully about wanting to be a director. There's no glory in being a director. A lot of spouses want to be a director because they feel that it makes them involved. Move them out. It's just not worth it. Limit the opportunity to be a shadow director. So you do that by either not having them involved at all or giving them a role other than a director and documenting that role. So when they say, oh, so-and-so turned up to the meeting, or so-and-so was doing this for the business and was operating the accounts, they're a director, I'm going to go for the spouse. You say, no, here's the employment for the spouse. This is the employment contract. They were the administrative officer or the administration person. And you've immediately rebutted the presumption that they were actually acting as a shadow director. If you don't have that, that's an avenue of attack for spouses to be brought into liabilities which ordinarily just be associated with directors. And then people say, well, how do I get control if I can't be a director? You can build veto rights into constitutions such that the directors have to ask you as a shareholder, and you actually have the ability to veto it. You can't propose something because then you're looking like a shadow director, but you can veto important decisions. And that's a way of giving indirect control without actually putting someone on the line as a director. So use companies to carry on a business, limit the number of directors, hold wealth represented by the shares in a protected place. And that's really the guts of companies. So the trust.